The patent prosecution phase is the phase when a patent applicant files their patent application with the Patent and Trademark Office and seeks to have that patent granted. During the prosecution phase, the Patent Office will evaluate that patent application for compliance with the standards for patentability. The standards for patentability are listed in Title 35, and they include the following elements. In order to get a valid patent, it must be fully and appropriately described. That's Section 112. It must be in compliance with the statutory bars of Section 102. Note that the statutory bars of Section 102 have recently gone away in the aftermath of a change in the law that occurred in 2013. However, most patents that are in force right now are still subject to the old statutory bar regime, so we will talk about both regimes in this course. The patents must be novel, which means they must be new. They can't be the same as anything that's already come before. They must be non-obvious, which means they must be a incremental improvement, or more than an incremental improvement of technology. They must be a real advance of some sort, a non-obvious advance. It must be the work of the inventors, so you have to assert as an inventor on a patent that you are the one who actually invented it, and anyone who helped you invent it must also be listed on the patent as a co-inventor. It must be useful. The standards for utility in the patent system are not particularly high, but they are there. You have to show some connection with real-world utility. And then it must be within the appropriate subject matter, which is Section 101. We will save the Section 101 inquiry till the end of our patent module, because really what subject matter we allow for patenting is a question of policy more than it is a question of law. So it's important to recognize that when we talk about standards for patentability, we're conducting what we call a patent validity analysis, and that this occurs at multiple points during the life of a patent. Most importantly, it occurs during the prosecution phase. In order to get a patent at all, you have to meet the standards for patentability, and the Patent Office is going to evaluate your standards, your application in light of the standards for patentability. But patent validity analysis also occurs in the enforcement phase. If you sue somebody for infringement of your patent will be evaluated for the standards of validity, because a defense to patent infringement is for your defendant to charge, to say that your patent is invalid, that it doesn't meet one of the standard, one or more of the standards for patentability. So because of that, a patent validity analysis is actually occurring all the time. People will be looking at your patent once it's granted and trying to evaluate it, sometimes hiring consultants at very high rates to evaluate whether or not there's a validity problem with your patent, and recommend a course of action as a result. During the prosecution phase, the PTO examiners assigned to the case, they evaluate all aspects of validity. During the enforcement phase, the patent is reviewed, the validity is reviewed by a court, and in some cases a jury, depending on exactly which issue and exactly how you set up the case. They can revisit, as I said before, any and all validity issues. There's a presumption of validity in the law, which means that you need to show clear and convincing evidence of invalidity in order to find a patent invalid. This basically means that we are assuming under the law that the Patent Office has done its job correctly, and it makes it a little bit harder to overcome the validity presumption when you're litigating. An invalidity determination is final, meaning that once in any case, if a patent is declared by a court to be invalid, then that patent can no longer be asserted against anybody else anywhere in the U.S., anywhere at all actually. So an invalidity determination is final. A determination of no invalidity is not final, which means that even if I successfully defend my patent during one litigation, the next time I litigate, that patent can be attacked again. often for the same exact issues. So in some sense, patentees have to continuously defend their patent as part of getting the rights enforced in the marketplace. Patent prosecution is what we call an ex parte process, meaning there are no outside parties involved. It's strictly between you and the patent examiner. It is private or secret for at least 18 months. At the 18-month mark, all patent applications are published on the PTO website unless patent applicants take steps to avoid it, which they can do, but many don't. You can have continuation applications, which means that when the Patent Office rejects your application for non-compliance with one of the standards for patentability, you can continue your application, often in an entirely new application, and essentially just keep the application going, keep trying to get your patent rights granted. And then we talked already a little bit about the internal incentives of the PTO towards granting patents, that it is a way of processing patents more quickly is to grant them more quickly, which can create incentives that are not necessarily aligned with what the public would hope the PTO is doing. There's an appeal process inside the Patent Office. The first step, if you wanted to appeal a decision by a patent examiner, would be to go to the internal Board of Patent Appeals and Interferences. If you are dissatisfied with the result there, you can appeal to the U.S. Court of Appeals for the Federal Circuit in Washington, D.C., or sometimes, in some cases, with a local district court. The re-examination and reissue processes are an opportunity for the Patent Office and, in some cases, the patentee, him or herself, to get a do-over on the patent prosecution phase. The re-examination is a re-evaluation of validity based on new prior art, typically. The reissue is where the party to the patent itself seeks to fix some kind of a problem with the patent. These re-examination and reissue processes have expanded in recent years, and we'll talk a little bit about that later in the course.